Assalamualaikum and hi madam and my fellow friends. My name is SYAMILIA and today I will be presenting my report entitled Salient Shariah Issues in Contemporary Application of Wadiah.
First, let us understand the concept of Wadiah. Wadiah refers to a contract of safekeeping under Sharia rules and regulations. In this contract, a depositor places an asset with another party, such as Islamic financial institution, for safekeeping and protections. There are two types of Wadiah. The first is Wadiah Yad Amanah or trust custody. Under these arrangements, the custodian keeps the asset purely for safekeeping and is not liable for any losses or damage unless it is caused by negligence or misconduct. The second is Wadiah Yad Damanah or guaranteed custody. Under these arrangements, the custodian is allowed to utilize the deposited assets and guarantees its return upon demands. This type is commonly applied in Islamic banking deposits. Next is the pillars of Wadiah, consists of four elements, namely the depositor or MOHD, the custodian or Wadi, the deposited property known as Wadiah, and the siga, which refers to the offer and acceptance between the parties. In contemporary Islamic banking, Wadiah is commonly applied in current accounts and saving accounts. The objective is to provide a secure and trust-based financial service while guaranteeing the returns of deposited funds. Hibah may also be given at the bank discretions. Now I will discuss the three main Sharia issues. The first issue is Wadiah Yad Damanah, resemble card or loans. Traditionally, Wadiah is a safekeeping contract whereas the custodian only keeps the deposited assets safely and returns it to the owner. However, under Wadiah Yad Damanah, the customer deposits money and the bank utilizes the funds and the bank guarantees full repayments. This creates a concern because when the bank utilizes deposited money and guarantees its returns, the arrangements become similar to cards, which is a loan contract. In a card contract, a lender provides money and the borrower uses the money and later returns the same amounts. According to the Sharia Advisory Council of Bank Negara Malaysia, money deposited under Wadiah Yad Damanah is equivalent to a loan based on cards. Therefore, the rules of card may apply to such deposits. The impacts of this issue include contractual ambiguity, different legal implications, and ongoing debate among Sharia scholars. The second issue is hibah in Wadiah Yad Damanah deposit may resemble riba or interest. Hibah refers to a voluntary gift given by the bank to depositor as a token of appreciation for placing their fund with the bank. The problem arises when hibah is given consistently and customer begins to expect regular returns. As a result, hibah may appear similar to interest. The concern is that customer may perceive hibah as guaranteed return. The voluntary nature of hibah may be compromised and similarity with interest-based product may arise. In addition, the original objective of Wadiah as a safekeeping contract may be misunderstood. To address this issue, SAC B&M allows hibah provided that it remains voluntary. It is not promised in the contracts. Customers have not right to claim it and it is not guaranteed in advance. The impact includes misconceptions among depositors, reduced distinctions between Islamic and conventional banking products, and potential Sharia compliance concerns if hibah becomes an expected benefit. The third issue is ownership and utilization of deposited funds. In a traditional Wadiah contract, the custodian only safeguards the deposited assets. However, in contemporary Islamic banking, deposited funds are commonly utilized for financing and investment purposes. This raises an important question. If the deposited funds are being utilized by the bank, can the arrangement still be regarded as genuine safekeeping contract? This becomes a Sharia concern because the utilization of deposit funds differ from the traditional concept of safekeeping. As a result, the original safekeeping functions may become less apparent. Nevertheless, Sharia scholars generally permit the utilization of deposited funds under Wadiah Yad Damanah, provided that the bank guarantees repayments, protect the rights of depositors, and clearly discloses the contractual terms. The impacts include the needs for clearer disclosure of fund usage, active utilization of deposited funds by the bank, and concerns regarding the preservation of Wadiah principles. In conclusion, Wadiah plays an important role in Islamic banking. However, its contemporary application, particularly Wadiah Yad Damanah, raises several Sharia concerns. The main issues discussed are the resemblance to cards, hibah resembles interest, and the ownership and utilization of deposited funds. Therefore, several recommendations can be made. These include enhancing customer education and awareness, improving transparency of deposit contracts, ensure hibah remains voluntary and non-guaranteed, and strengthening Sharia governance and disclosures.